Good afternoon. Trying to bring this classroom into order. No, this is not a class. I'm Peter Karstensen. I'm chair of the Kastenmeier Lecture Committee, and I've been given the honor of doing the initial welcome and introducing a couple of the initial speakers. Before doing that, I would like to recognize and acknowledge the presence of 20 judges from Shanghai, China, who have joined us for this lecture. They are here on a training program that the University of Wisconsin Law School does in conjunction with Shanghai. Welcome. And now it's my great pleasure and honor to offer a very brief introduction to Bob Kastenmeier. Bob graduated from this law school in 1952. He served in Congress from 1958 to 1990. He also has the somewhat dubious distinction of having moved my admission to the bar of the United States Supreme Court. But don't hold that against him. In all other respects, he was an outstanding congressman. And so it's an art we seem to have lost in our Congress. He worked across the aisle. He did some enormously important work in a variety of difficult and challenging fields, especially in the patent and copyright area, as well as matters of criminal justice and much of the work between the federal courts and the Congress. So Bob wants to say a few words of welcome. Bob.
Thank you, Peter. And I'd like to extend a welcome to everyone here, including our guests from China. I'd first of all like to thank a number of people for making this program possible. Kim Frank really worked very hard in putting this together, along with Teresa Evans and some of our people like Bill Kaplan, who's here. Indeed, all of our board was enthusiastic about this program. But I'd like to take just a moment to reflect on a sad note. Early last month, one of my very best friends died, but he is well known to many of you. He's Dick Cates. Dick, sometime teacher in this law school, one of the hardest working lawyers that I think the practice has ever seen, and just a wonderful human being. I know he put his own practice aside to come to Washington on 2 occasions to help us with impeachment process. Dick, as I say, will be sorely missed by me and by many, many others. As to our program today, I should at least mention that this is going full circle. Our first lecture in 1992 was William Rehnquist on the federal judiciary. The Chief Justice came here, and we were very happy to have him. But that was the last, I think, major lecture we've had on the subject of the federal judiciary. And so we've come here 19 years later to pick up on that theme. It's a theme that I'm personally very much into because my subcommittee I chaired the subcommittee that dealt with the federal judiciary on the Judiciary Committee. And while we didn't deal with who was appointed or confirmed to the courts, only the Senate could do that, and I leave it to you to decide whether they've done a good job or not over the years. And judicial pay, that was another subject not in my committee. But virtually everything else, impeachments, Everything else was in my committee that dealt with the federal judiciary. In fact, Chief Justice Berger used to, at his annual judicial conference, held once, as I say, annually, in the Supreme Court, would invite at least two outsiders, the Attorney General and one member of the Congress, and that was me. I was there probably to answer the negative aspects reflected by Attorney General Meese about the courts, but that was a period when even at that time we were fighting about whether we had true judicial independence. And that was a period that I think is largely now passed over, but it was a time when many people outside the courts were concerned about the courts. One other comment I might make, historically, it is thought that, probably true, that the Senate and the House are made up of at least 50% lawyers. That this may be true today, may not be, I don't know. But what I did find was that there was really a lack of concern in the body, in either body, for the judiciary. You would think with so many lawyers whose nature would be to be concerned about the judicial system, that wasn't necessarily true. In any event, I'm looking forward to today's presentation, today's lecture. It involves a person I've admired for many, many years. And right now I'm going to pass it back to Peter.
And now I have the privilege of introducing our new dean, who will in turn do the introduction of our speaker. Margaret Raymond came to us this summer. We imported her from Iowa, where she had had a very distinguished career as both a scholar and a teacher. We did not inquire why she wanted to become a dean. We were just absolutely delighted at that slight gap in her otherwise impeccable career. She's a graduate of Columbia Law School. She has clerked for Justice Marshall. And as I say, we now have her as our dean, and I am delighted to introduce her.
Thank you, Peter. I'm delighted to welcome all of you to the 2011 Kastenmeier Lecture. We should say a little bit about the lecture series. The Kastenmeier Lecture is supported by a fund established to honor Representative Kastenmeier, a graduate of our law school with 32 years of service in the U.S. Congress. In honor of his many contributions, the fund that supports this lecture focuses on areas of his interest and expertise, including, as he told you, the improvement of the judiciary and the administration of justice. In light of that focus, I'm especially delighted to welcome today's speaker, the Honorable Barbara Crabb. Judge Crabb, a Wisconsin native, is also a distinguished graduate of the University of Wisconsin Law School, where she served on the editorial board of the Wisconsin Law Review and was elected to the Order of the Coif. She graduated in 1962, practiced in a private firm, and somehow we managed to get her back. She worked as a research assistant at the law school for some time before becoming a part-time magistrate judge. After 8 years serving first as a part-time, then as a full-time magistrate, she was appointed United States District Judge for the Western District of Wisconsin in 1979. She served for 25 years in 2 different stints as Chief Judge of the Western District, and after 31 years of active service on the bench, took senior status in 2010. She has maintained a remarkably active schedule of travel, teaching, and varied committee and institutional service, including extensive involvement with the American Bar Association and the Judicial Conference of the United States. Given her extensive experience, her talk for today, Bridging the Divide Between Congress and the Courts, promises to be fascinating. Please join me in welcoming the 2011 Kastenmeier Lecturer, Judge Barbara Crabb.
Is there some water here? Thank you, Dean Raymond. It's a special treat to be able to meet you after I just read about you and heard about you. Dean Raymond, Bob and Dorothy Kastenmeier, Kastenmeier committee members, distinguished guests, especially those from Shanghai. And I should mention that my absolute most wonderful traveling experience was an opportunity to go to Shanghai in 1998 and work with the judges over there. Before I start, I want to give a special thank you to the members of the jury who returned a verdict before noon today so that I can come here unencumbered. It's an honor to be one of the many speakers who have taken part in the Kastenmeier Lecture Series, just as it is an honor to serve as a judge in the Robert W. Kastenmeier Federal Courthouse. I hope that you consider the naming of the courthouse for you as an honor. You should, if only because you're one of the few people who had a courthouse named after them when they're still alive. But I remember the day that we had the commemoration of the naming, if that's what you call it. And before the festivities began, Kenton Peters, who was the architect of the courthouse, was standing out in front, watching the workmen put the last letters of Kastenmeier onto the building. And he was contemplating his work with satisfaction until a man walked up behind him and said, "I wouldn't want my name on a building like that." So I told some deputy marshals this afternoon who asked what I was about to do, and I said I was going to give a lecture, and they said, "What is it about?" And I said, "Well, it's about how judges can talk to Congress." And they looked at me and they said, "How?" And I said, "Well, they can't really." The end. It does seem a little quaint and out of step to be talking about bridging the divide between the courts and Congress when all eyes are on the relationship between Congress and the president. Now, I'm not here to say that we're as important as that relationship, but I am suggesting that we reserve at least a small amount of concern for the state of the relationship between Congress and the courts. It may not be as headline-grabbing as the tension between the other two branches, but it's a relationship in which everyone has a stake. It doesn't matter just to judges that the judiciary is adequately staffed and funded, and that it has the independence to decide cases solely on the basis of the Constitution and the laws. It matters to everyone. That there are divisions between the branches of government is nothing new or unexpected. Quite the contrary. The divisions are the natural, intended consequence of our system of government, which was designed to be a divided, balanced, and limited national government. To create a government that would not only control its constituents, but control itself, the framers of the Constitution gave each branch what they believed were the necessary constitutional powers and personal motives they would need to resist encroachment by the other branches. Well, maybe not quite when it came to the judiciary. The framers gave offsetting powers to the legislature and Congress and the executive branches. But when it came to the judiciary, their efforts to achieve balance were less successful. The framers drafted 3 constitutional provisions to ensure the independence of judges: housing the judicial power of the national government exclusively in the judiciary, giving federal judges life tenure, giving federal judges a lifetime salary that could never be reduced. But they put off deciding whether the national government needed a system of lower courts. They just sort of kicked the can down the street and provided for such inferior courts as the Congress may from time to time ordain and establish. Maybe this was because the framers had used up all of their energy and imagination before they reached Article 3. They'd been engaged in long and contentious debates about the presidency, about the legislature, about what powers each would have. Maybe that explains why they failed to see that they had not protected the judiciary from encroachment by the other branches. Alternatively, it might be that they simply lacked the experience with an independent judiciary to be fully aware of what such a judiciary would require. Whatever the reasons, the framers established in 2 sentences a system in which the judges were to be independent, but the judiciary as an institution was not. If Congress could decide what inferior courts could be established, it followed that it could decide whether and how those courts would be housed, staffed, furnished, secured, and maintained. Congress would have the authority to create new judgeships, confirm new judges, determine the court's jurisdiction, as well as most aspects of the court's organization. And because the Constitution said only that judges' salaries could not be reduced, Congress would decide whether those salaries would ever be increased. They've taken a long time about that. Congress would be responsible not only for passage of all the laws that the courts would be enforcing, but for the rules governing the procedures the courts followed in deciding cases. The result was a judiciary that was both the least dangerous branch, as Hamilton famously described it in the Federalist Papers, but the most vulnerable. As Hamilton explained, the executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. Charles Jay, who is a federal court scholar and I think a graduate of this law school, and didn't he work for you at one point? I think so. Anyway, did he? He's written about the difficulty of reconciling the idea of leaving the support of the judiciary to the legislature with the founders' widespread commitment to constitutional separation of powers. He says that the judiciary could be wholly dependent on the legislature and still be expected to exercise judicial power in ways that justified separating legislative from judicial power in the first place, underscores how supremely trusting the fledgling states were of their legislatures and how little they had actually thought about the separation of powers as it applied to the judicial branch. This, then, is the reality of the federal judiciary: decisional independence, institutional dependence. I'll just for a little background, I'll tell you a little bit about the court structure that Congress established. In its first session in 1789, it did establish inferior courts. A tri-level court system with the Supreme Court at the top, a federal district court in each state, and regional courts of appeals. Those regional courts of appeals were not what we're used to today. They were made up of the local district judge plus 2 justices of the Supreme Court who were to ride circuit. an arrangement that continued in one form or another for more than 100 years. And imagine what that was like on horseback, the country getting bigger and bigger and bigger, and the justices having to travel farther and farther away from the capital. It's relevant to today's topic that for much of the time, Congress refused to reimburse the justices for the cost of their travel. And that situation led the first Chief Justice, John Day, to turn down an opportunity to return to the court after he had served as special envoy to Great Britain and as governor of New York. The 19th century courts had little structure and few administrative needs. Generally, a district court consisted of a judge and a clerk. The workload was light. There was little federal legislation. One early justice of the Supreme Court reported that the court had heard only 4 cases in 4 years. Be nice. It was only at the end of the century that Congress created the Court of Appeals in the form we know them. It took another 30 years before the judicial system began its transformation to a self-governing judiciary. In 1922, Congress authorized the establishment of what is now the Judicial Conference of the United States, made up of the chief judge of each circuit and headed by the Chief Justice. It was to meet annually, make policy, report on the condition of the dockets in each circuit, and submit recommendations for improving the administration of justice. In 1939, Congress established the Administrative Office of the United States Courts, subject to the control of the Chief Justice and the Judicial Conference. Congress gave the office financial control of the lower federal courts and primary responsibility for administration of the federal judiciary. Before this, the court's funding came through the Department of Justice, an awkward situation when the department is the most frequent litigator in the federal courts. In 1967, Congress authorized the establishment of the Federal Judicial Center, which is the court's research and educational arm. These major changes in court administration put the judicial branch on a firmer footing than it had been in the 19th century, but kept the judiciary dependent on Congress still for confirmation of new judges, for judgeships, courthouses, funding. The same situation exists today, as we know. The courts have no right, no mechanism, to be heard on congressional decisions to expand or restrict the scope of the court's jurisdiction, or to enact laws that will increase the court's workload. In other words, when it comes to matters affecting institutional independence, the judiciary has no constitutional protection, and its power is limited to persuasion. When an entity has little power in a relationship, it behooves it to assess the sticking points between it and its protagonist, husband carefully what little power it possesses, employ all the diplomatic skills at its command, look for areas in which the interests of both parties are in alignment, and seek ways to enhance what little power it has. Between Congress and the judiciary, the sticking points are legion. If you doubt that, Representative Judy Biggert of Illinois could convince you otherwise. In a 2006 speech to the American Bar Association, she told about soliciting her colleagues to join her in co-sponsoring a bill to give judges a pay raise that would make up for 6 of the 9 cost of living increases they'd been denied in previous years. These are some of the responses she received. Not until those judges leave the legislating to Congress. They aren't getting theirs until we get ours. Why should they automatically get a raise when their jobs are safe, while every 2 years we have to fight to get reelected and keep our jobs? Their rulings are outrageous. Or, this is the saddest one, I just don't care. As these comments show, the whole idea of judicial review of legislation raises hackles among legislators. They envision self-righteous judges acting as the superego of another branch to keep it within its authorized limits. A scenario comes to mind of an elegant dinner, much fussed over in advance. All menu, napkin colors, flowers, china has been agreed upon. The night of the dinner arrives. The candles are lighted. The doors are opened. But wait, in marches an uninvited guest who takes a hard look at the table, the gleaming silver, the starched linens, and whips the tablecloth out from under the feast. The high-handedness of this, the nerve. Who would not react negatively when an outsider undoes the hard work of others? Why then should we be surprised if legislators react negatively when an unelected judge calls a piece of legislation unconstitutional, undoing the efforts of many people? One can imagine the legislators thinking to themselves or saying out loud that the judge didn't do the heavy lifting to get the legislation approved. She wasn't there for the midnight sessions. She wasn't corralling party members to persuade them of the value of this particular piece of legislation. She doesn't know the compromises that were necessary. At such times, it may be hard to remember that the judge is simply carrying out her duty, not flaunting her power. And hard to remember, too, that the judge's decision is not unconstrained. She's bound by precedent, the terms of the Constitution, statutes, procedural rules, the factual record, and legal principles. And unless the judge is a member of the Supreme Court, her power to overturn a statute is heavily circumscribed by the availability of appellate review by at least 3 judges of the Court of Appeals and eventually by all 9 justices of the Supreme Court. It is true, of course, that not every legislator feels a personal affront when a statute is ruled unconstitutional or even misread. Some were not in office when the legislation was passed. Others opposed its passage and are glad to see it overturned. Others voted for it only because they anticipated it would be overturned. Let the courts do the dirty work. Nevertheless, the fact that judges have this responsibility is a source of irritation. But it's not the only one. As Representative Biggart's colleagues pointed out, it is hard for many members of Congress not to resent the fact that judges have a guaranteed salary for life and that they have life tenure, which means that they are freed from the worries of re-election. Judge Frank Coffin, who served on the Court of Appeals for the First Circuit and was a former legislator, described the heavy price that legislators pay in the form of a bifurcated life. Between home and the Capitol, between public and private life, the frustrations of having to scatter one's energies, of never being able to know very much about anything, of always having to read on the run, and the haunting specter of the next election. Variety, breadth, respect, and influence on the one hand, lack of time, depth, privacy, security, and serenity on the other. For judges to have any chance of bridging the divide between them and Congress requires a willingness by them to consider the courts from Congress's point of view and to appreciate the constraints and pressures under which Congress operates. The members are besieged by demands on their time. They're engaged with myriad different and difficult issues. They have little time to listen to judges seeking help for the judiciary. And when they do meet with judges, the conversation can be quite strained. If judges view their entreaties to Congress as limited to matters necessary to strengthen the judiciary and maintain its ability to function effectively, they're not necessarily perceived that way. Judges may promote requests for salary increases, for instance, as needed to keep talented judges on the bench and keep encourage outstanding lawyers to apply for judicial vacancies. Congress is more likely to view those requests as self-serving. Judges ask to be treated as an independent, co-equal branch when it comes to funding for operations. Congress hears the request as a statement that the judiciary believes its needs are more important than those of any agency. When judges oppose legislation that would add extensive new duties for the courts without offsetting staffing, Congress may read the opposition as the complaint of lazy judges unwilling to pull their own weight. After all, members of Congress are overworked and under pressure too. In other words, it's hard for even a sympathetic legislator to view many of the requests from judges as anything other than special pleading. It does not improve communication between the two branches that the members have almost no opportunities to meet, except when judges have a complaint or when they want something from Congress. Moreover, because judges are bound by the judicial canons of ethics, they cannot help raise money for candidates. They can't contribute to campaigns. They can't endorse a candidate. They can't hold a fundraiser. It's understandable that members of Congress ignore judges that they see as special pleaders, and they choose instead to devote their limited time to meeting with the people who can help them, listening to the concerns of their constituents, or even reacquainting themselves with their families. The difficulties of this relationship make it all the more important that judges make the best use of whatever power they have and employ it sparingly. Applying this principle of parsimony effectively requires the wisdom to decide those matters that are both critical to the judiciary and within its powers of persuasion. One of those that I would include within the ambit of critical matters was one that the judiciary took to Congress in 2002. And that came after Congress had passed an initiative that included many comprehensive measures to stop illegal immigration, or at least reduce it, and to interdict drugs along the southwest border. 5 years after the legislation was adopted, it became clear that this initiative would fail at the courthouse door unless the courts had new resources in the form of judges, courthouses, staffing, and detention facilities. Lots of money was allocated to Treasury, Border Patrol, etc. No one thought about the courts. Organizing all their allies, the judges from the southwest border courts, who were completely swamped and unable to deal with the cases they were getting, went to Congress. They concentrated just on getting funding for those courts that were hurt by the particular initiative. They had fact sheets showing things such as the number of arrests each year, which was more than 1 million. The detention facilities, 200,000. They were successful. They convinced Congress of the need for adequate court staffing, new or expanded courthouses, and additional auxiliary services to handle the flood of immigration and drug cases. One might ask why it was necessary for the judiciary to go to such lengths to obtain funding for this initiative. Why didn't Congress consider and provide for the cost the courts would have to absorb when they passed the legislation? One reason is there's no mechanism, no common practice, no incentive for Congress to do so. Often bills that will require funding will carry a mark to that effect. It would be ideal if bills that had an effect upon the judiciary would have the same thing. Had such a mechanism been in effect in 1996, when the border initiative was enacted, I reminded Congress There's more than just enforcement involved. There's also the judicial system that has to be considered. At its best, a judiciary mark on legislation might cause Congress to think harder about a particular bill's effect upon the judiciary. Will it require more judges in the increased funding that goes along with each new judge? If it will, does Congress want to increase the judiciary for this purpose? When it comes to expanding the judiciary, Congress has reasons not to do that go beyond funding. There's the principle that the national government is one of delegated powers in which the residual power remains in the states, the concern that a large expansion of the judiciary will alter its character, and a reluctance to devote more of Congress's and the President's time to the increasingly divisive task of nominating and confirming judges. Perhaps in these times of deficits, such a mechanism would turn attention to the feasibility of alternatives to an ever larger judiciary. Congressman Kastenmeier and Mike Remington wrote 32 years ago that the legislature has 4 options when dealing with a finite resource such as the judiciary. It can expand the resource. It can substitute for the resource by redirecting litigation to alternative dispute resolution institutions. That might be state courts, arbitrators, mediators, administrative bodies. It can conserve the resource by eliminating inefficiencies or by simplifying procedures. And it can ration the resource by limiting its availability to all litigants or by barring access to certain groups of litigants. These options merit study by the courts and by legislators both. They might ask whether diversity jurisdiction is still needed to protect the rights of out-of-state parties from local prejudice in state courts, whether an invigorated form of administrative review would be adequate to protect the rights of disappointed Social Security claimants, and even whether the country should draw down its troops in the war on drugs. It is inevitable that from time to time, Congress will propose legislation that the courts find threatening to their independence. What can the courts do when this happens, and what should they do? As a practical matter, there's little they can do unless the legislation is a true threat to decisional independence, which is the security for judges to make unpopular decisions. Presumably, in that situation, the courts would decide the constitutionality of the legislation. When it is a threat only to institutional independence, which is not protected by the Constitution, the courts are limited to what I've been talking about already: persuasion, diplomacy, compromise. Consider the Civil Justice Reform Act, which was proposed in 1990 for the purpose of reducing the cost of litigation. Admirable goal, but they had no consultation with the judiciary before they proposed this bill. The judges found it overly intrusive. It attempted to prescribe exactly how courts should handle civil cases, when they should hold pretrial conferences, who should hold them. Magistrates would not be allowed to do that, only judges. How quickly they could get cases to trial. It required analyses of caseloads, semi-annual reporting of motions under advisement and cases that had been pending for more than 3 years, a whole committee structure, annual reports about how the structure was working, on and on and on. But Congress was right about the need for improvement by the courts in the way they manage cases. The judiciary system was not functioning well. It was not transparent, and there were wide variations in the support that individual courts gave to their judges. But instead of meeting with the judges, or a few of them, to consider what they would need to implement better systems, Congress simply announced what the courts must do. There's no surprise. The judges greeted the initiative with all the enthusiasm that Congress would have mustered if the court had held that its committee structure was unconstitutional. In the end, tactful overtures to the staffs of the Senate Judiciary Committee by a member of the Executive Committee of the Judicial Conference, together with a magistrate judge known for his negotiating skills, achieved modifications that were acceptable to the courts. And several lessons can be learned from this episode, one being the importance of responding in a measured way to legislation that seems overreaching. Going head-to-head with the legislature is rarely effective. Judges seem to have more success in their dealings with Congress if they proceed with the deference and bearing of an ambassador to a foreign country. And I'm perfectly serious about that. We are different countries to one another. We don't know that much about the other. Another lesson is being realistic about what can be achieved, when to hold and when to fold your cards. The court's representatives did not achieve every change they wanted in the Civil Justice Reform Act, but they had the wisdom to know when further efforts would be counterproductive. It follows from the parsimony principle that judges should put less effort in the matters that are seen as special pleading. First among them, any increases in salaries. Much as judges might see stagnant salary levels and the constant denial of cost of living increases as a deterrent to attracting and retaining qualified people on the federal bench, Congress has made it plain it does not share that view. Still, another matter deserves mention. Communicating with Congress is more effective when the judiciary speaks with one voice. The chances of persuading Congress of the wisdom of any legislative initiative rise when the backers are united on its importance. With only limited power of persuasion with which to protect its institutional independence from other branches, the judiciary needs to find other ways it can strengthen its hand. In an article written in 1995, two good thinkers from the Federal Judicial Center, Russell Wheeler and Gordon Vermont, identified a not-so-obvious strategy. They suggested that neither Congress nor the executive really wants to intervene in procedural and administrative judicial branch affairs, if only because there's little political capital to be gained by the intervention. It kind of goes to the I don't care aspect. Thus, if the judiciary is perceived as imposing on itself very high standards of accountability for official conduct, fiscal prudence, and efficient operations, then the political branches have little incentive to initiate additional procedural and administrative interventions. This is such a good suggestion. It also brings me back to the Civil Justice Reform Act. Despite the fears the legislation engendered among judges, their compliance with the modified act reduced Congress's concern about their accountability for their dockets. Court dockets are now transparent to the public and to Congress. Similarly, the judges' implementation and enforcement of the Judicial Conduct and Disability Act have demonstrated that the judiciary can be trusted to police its own ranks and discipline judges who engage in acts of judicial misconduct that are not sufficient for impeachment. Finally, on this point of the benefits of accountability, the judiciary has become an increasingly careful steward of the money allocated it by Congress. For the last 8 years, it has been engaged in a cost containment effort. It has imposed new restrictions on the size and cost of courthouses, adopted measures to cut the cost of chamber staff, cut the size and numbers of chambers libraries, and improve the court's utilization of jurors. It has regularly returned unspent money to the government. This self-scrutiny and frugality have become powerful factors in persuading Congress to give the judicial branch the full amounts of its budget requests in recent years. An obvious force multiplier is to have allies to speak on one's behalf. For courts, the obvious allies are the various bar associations because they have a stake in the effective functioning of the courts. But the judiciary should not overlook the continuing need to educate the public about the importance of an independent judiciary As Justice O'Connor has been reminding us, judges and lawyers should not assume that the idea of judicial independence is universally understood and appreciated. Of course, the best ally is a legislator who is a student of the third branch and cares about the effective functioning of the courts. We had one of those in Robert Kastenmeier, who served in Congress from 1959 to 1991. For many years, he was the ranking majority member of the House Judiciary Committee. He chaired the subcommittee on courts, intellectual property, and the administration of justice, as you've heard. In that role, he helped create the State Justice Institute, helped reduce much of the mandatory jurisdiction of the Supreme Court, giving it far greater discretion over the appeals it accepted, promoted and oversaw the establishment of the Court of Appeals for the Federal Circuit, which, among other things, hears all appeals and patent cases. He worked to expand the federal magistrate system, and he championed the Federal Defender Program, which provides highly qualified criminal defense lawyers to persons charged with crimes, and he played a large part in reorganizing the bankruptcy courts. Bob Kastenmeier was the judiciary's friend but not his agent, as Russell Wheeler once noted. He, as both an outsider and a careful student of the courts, he wanted them to have the resources they needed to work more effectively. And he also wanted to make sure they were working for the public good. In his mind, accountability and judicial independence were not mutually exclusive goals. He advocated accountability and openness. He supported the televising of court proceedings. He was in favor of financial reporting by judges. And he was the author of the Judicial Conduct and Disability Act of 1980, which made it easier for citizens to complain about actions by judges they believed to be ethical or legal violations. Without someone like Bob Kastenmeier in Congress today, the judiciary has to work much harder and more imaginatively about its communication with Congress. That's why it's important to think about the ways in which courts should improve their communication. In addition to the strategies I've mentioned, another is for judges to foster personal relationships with individual senators and representatives in the hopes that this will lead members of both branches to a better understanding of the constraints under which the others operate. I'm pleased to report that Chief Judge Conley has done this in the Western District of Wisconsin. Both new Representative Sean Duffy and new Senator Ron Johnson have visited the courthouse since their elections last year. Both spent time in the courthouse meeting with staff from the clerk's office and from the probation service, as well as with the judges. In our system, one thing is certain. The judiciary cannot unilaterally resolve issues about matters of federal court jurisdiction, continued federalization of crimes, the size of the judiciaries. As judges, dependent on Congress for the tools we need to perform our jobs, we have no choice but to continue trying to open the channels of communication with the members of Congress. For all of you who've sat so patiently through this talk, I'd like to be able to say I found the key to doing this, that I have identified the one course judges can pursue to achieve rapport with Congress on whatever contentious issues divide us. Obviously, I have not. It remains the case that maintaining the delicate balance between the two branches is a matter of trial and error, advance and retreat, success and failure, overtures and rejection, incremental steps, small adjustments. Perhaps, after all, this is exactly what the framers of the Constitution had in mind. Thank you.
Judge Crabb has graciously agreed to take some questions, and I think we have a staff person with a mic. So if you have a question, raise your hand.
We're going to say you had a plant in the audience to ask.
Well, there may be one. There may be one. Questions? Mike's coming your way.
question I kept having in mind as I heard you was your last part, namely, if you were to redraft it and you could get a constitutional amendment, would you make the federal judiciary institutionally free from the legislature or the executive?
Probably not, but it would be nice to have a self-sufficient budget like you do.
Somebody didn't tell me I had that. Here I've been existing all these years and thought that my budget was set by the executive and legislature. So although it says some sufficient, it's a fixed budget. You can go back, but the
idea is a good one.
Pardon me?
The idea is a good one.
That's right.
But as somebody said, you want your own budget? Look at the post office.
Right, or go ahead and raise your own taxes, or do it on surcharges or charges, and so that is just a very difficult thing. And I agree with these various strategies, but doesn't the administrative office have whatever you want to call it, a lobbying team that watches all the legislation that is coming through and does judicial impact? I mean, they're not precise, but impact statements, and staff goes to staff. I mean, there's just a lot of communication, I think.
And it's been greatly increased under our recent director. There's been a much greater effort. We don't have, there's been a cap on adding positions to the administrative office. We don't have minions and minions running around checking lobby. But yes, there is close.
I mean, because there is at the state level too, we miss some bills and we don't get our way, but theoretically we have the opportunity to say something and send letters and to do a variety of things but we don't always get our way.
But I think that particularly under our recent director, that he was much savvier about utilizing that technique and working staff to staff, because that's where the decisions get made.
I agree with that. But let me put in a plug for outreach and getting the public to understand. And I have discussed this many times, and it is very important that there be a constituency. And if it's not going to be legislators, then they have a constituency, and it's the same as the courts. And the people think of judicial independence as being not accountable, whereas judges think we are accountable. And that it's very important to explain this. So, and it doesn't matter whether you're a federal or state judge, because the people don't know the difference.
That's right. As we know well.
As we know well. So, we're going to be in touch with the federal judges, because I'm rolling out yet another outreach program in the state of Wisconsin for very intensive, and would like the federal judges to join us in inviting the constituents into the courthouse and doing programming and going out with us. You want to start next week? It's Dodge County. So I say all that facetiously, but with some deep understanding that we need a constituency. It has to be the people. And that's what all government officials understand, what the people say. And it's not a one-shot deal. It's all in our lifetimes. And it includes every member of the bar here, and every faculty member, and every student. You can join us. Just give me your cards or your names. End of speech.
having been through the appointment and confirmation process and observed some pretty disagreeable state elections and a backlogged confirmation process on the federal level, the terrible elections on the state level, do you have thoughts on the most efficacious means of selecting and designating judges?
It might be self-selection.
Your comments tonight were between Congress and the judiciary. What is the relationship between the executive branch and the judiciary, and would that be another lecture that would have some of the same tones?
You know, it's so completely different. Really, our relationship with the executive is through the U.S. Attorney's Office. It's practicing before us all the time. Now that our funding isn't controlled by the Department of Justice, we really, you know, other than we'd like presidents to nominate good people to be judges, really doesn't enter into it too much. I mean, we're definitely working at the ground level with the people from the Department of Justice and the U.S. Attorney's Office.
Last summer, the Seventh Circuit ruled on Seifert v. Alexander, a case that was a judge's First Amendment challenge to certain aspects of the judicial code. In your opinion, do you think that maybe lifting some of those restrictions in the judicial code as far as political advocacy, joining political parties, and speaking out more is a way of gaining constituents, or is the danger of partisanship just too much?
I don't know. You know, it's up to Congress or states to decide what's good policy. I only look at what I think is good law. Obviously, I was wrong on a couple of points in Seifert. But it was interesting. A friend of mine was deciding the same case in Minnesota at about the same time. Things that she ruled unconstitutional that I ruled constitutional were overruled by the Eighth Circuit, and other things were overruled by the Seventh Circuit. Clearly, we do not have an agreed-upon understanding of what restrictions are appropriate and which ones are not.
Please join me in thanking Judge Crabb for a really thought-provoking. Traditionally, we have a presentation for our Kastenmeier Lecture. So those of you who know anything about the University of Wisconsin Law School know about the iconic symbol of the gargoyle. And actually, our Kastenmeier Lectures receive their own personal, individualized gargoyle. Judge Crabb, this is for you. It's ugly, but it's us. We will arrange to get it back to your office. And now I'd like to invite all of you to join us in the atrium for a reception where you'll have the opportunity to visit with the judge and the representative and all of our other guests. Thanks so much for coming today.